Is the H-1B lottery dead? A new $100,000 fee could change everything. Students, workers, even employers. So stay tuned because our immigration attorney is going to break it down live. So, yes, welcome everyone to Immigration Talk Show. I'm Nipasa, your host for today. And please help me welcome our guest, none other than Attorney Justin Rivera from Wasden Immigration Litigation. Hi, Justin. Thank you for joining us.
Hey, thank you for having me. It's nice to be back again. Hopefully, the internet connection is significantly improved this time.
It looks good today. Thank you so much. And before we start off, friends, we have this important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So stay with us, friends. We are streaming live right now on YouTube. And you can also check us out on LinkedIn, Facebook, X, and on Instagram. And feel free to comment wherever you're watching us, wherever you have joined us from. Comment whatever questions you have because we are lucky to have Attorney Justin Rivera with us for, say, about 30, 40 minutes. And let's try to get answers. All right. So another good thing is you can join us on call, and the number where you can dial in to ask your questions live right now is displayed on the screen above 425-436-6335, and the access code when they ask for it, you need to dial in 988-888. So check us out. And yes, subscribe to our channel. Our handle is at Immigration Talk Show. So, Justin, now, well, the big question, how will the new wage based lottery system affect my chances, with the H-1B lottery overhaul right now?
So, the H-1B lottery proposal, first off, let's clarify, it's a proposal. And the proposal, like all proposals, has to go through notice and comment period before they're allowed to create a new policy. So, taking that into effect, we're looking at the introduction of it being, late-ish September. 30 days for comment, 60 additional days for review. You're probably looking at December to January if they're able to push the final rule to get it implemented. I'm assuming the administration's goal is going to be to have it applied to this year's lottery. That being said, I could see a world where it gets pushed to next year. You have to also realize when a policy is implemented, a final iteration of policy, uh, the institutions that it impacts have to be allotted a sufficient amount of time to change their systems in order to, deal with it. So in this circumstance, what has been proposed is basically a weighted lottery system, a system in which at the time of submission, you will need to be able to provide the individual's work location, SOC code, and of course, what everyone has been talking about, wage level. So the way it works is level 1 for an individual will constitute 1 entry into the lottery. Level 2, 2, 3, 3, 4, 4. So what does that mean? It means that an individual filing at a level 4 has 4 bites at the apple, whereas someone at a level 1 has only 1. The perceived goal or justification behind this is to to strongly promote the highest paid individuals who the government opines will be the most skilled. So those individuals should receive the highest level of weight. Um, the government's implementation of this would be very difficult were the rule to be implemented in, let's say, February, because the lottery is in March. So absent the government proactively installing these systems to allow for the weight, I think it would be very difficult for them. You also have to factor in the threat of litigation because this will be litigated. At the end of the day, the people, the institutions most impacted by this are going to be mid-sized to small-sized companies because they lack the capacity to pay that higher wage level. So I'm almost certain that you would see litigation, potentially a preliminary injunction preventing the implementation of the policy. So I don't know if this makes it into the next year's lottery. Further, we can get into it later. I actually have questions about the legality of this as well. But just to generally give you an overview of the process, it's the 1, 2, 3, 4. The higher up you are, the more opportunities you have to be selected. This system does not replace the master's exception. So, there's still that two-tiered system where you get the normal lottery and then the master's lottery. So that still exists. So the people who are going to benefit the most from this will be people who are filed at a level 4 wage that have master's degrees. And then the people who are going to be hit the absolute hardest by this as individuals are going to be people just graduating college. People who are probably going into the lottery for their first or second time, who simply are not going to be capable of finding employers willing to sponsor a level 3 or level 4 wage for someone that just graduated with a bachelor's degree.
Right, so true. And I mean, getting a foreign degree, students, international students who have been working hard and on their OPT and trying to get into that transition into H-1B, it's scary when you think about it. And also, like you were saying about mid-size, but also the bigger companies, because they have a lot of international staff that they hire, right? And it's all through H-1B if you think about it. And if they have been hiring a good number of them, then they will have to rethink the number and maybe try to hire somebody from, I mean, locally. I don't know how far is that possible, or what is going to happen. But there are just too many questions right now, Justin. And I can see Ricky, who has joined us with a lot of questions. So I think we should take up one from his side as well. So he's saying that, hello, thanks for the session. Will 100K dollars have to be paid for case of concurrent H-1B filing by a second employer after 21st September? By when do you expect to get more clarity on this as well as transfer?
So I think that everyone in my profession is doing their best to come down on a unified understanding of what Friday's proclamation means. Okay. So far, the government has alleged that the fee will be paid for new petitions and will be implemented as of Sunday. Conflicting information has been provided by the federal government, the same entity that made that prior statement, stating that those fees would not become applicable until the lottery. So it's confusing, to be honest. We don't have actual clarity. Here is my analysis of it. And I'll put it this way, and I will tell you, I think it's right, but I can't say that with 100% certainty. As of today, to my knowledge, there does not exist a mechanism for submission of the $100,000 fee. What I mean by that is there's been no clarity defined as to whether the fee is supposed to be submitted with the petition, either via a check or a credit card or whatever. If the fee is supposed to be submitted to another entity or through another mechanism. There's no mechanism that exists to show how the individual applying for the petition procures a receipt, this alleged receipt that they need in order to show that they have paid the fee. So because of that, and because of the fact that the governing part of this EO is 212F. 212F is for entry into the United States. So I think the government would have a very difficult time, if not an impossible time, trying to enforce a payment of this fee for an individual that is already in the United States. So the lack of a mechanism to implement this, plus the fact that 212F seemingly should only apply in circumstances for individuals not present in the United States at the time of filing would lead me to believe that present petitions for individuals in the United States on H-1B will remain the same. Now, that is a speculative statement, but it is a statement that I make having looked closely at this, spoken with other professionals in my field, and, tried to wade through all of the nonsense that has been put out in addition. So, for your situation, a concurrent filed H-1B, I would assume is safe. That being said, until raw data appears, until we actually have people saying, my transfer has been receipted, my extension has been receipted. I think the extensions are actually fine. Bad example. My new employment change of status has been receipted. We won't know with absolute certainty. But in my opinion of it, the best way the government can defend this, and that's setting aside the fact that the legality of this is dubious, the best way they can defend this is by clarifying that it's only applicable to individuals that are outside of the United States and therefore subject to 212F. That argument also supports the idea that the basis of the proclamation is to prevent entry from additional high-skilled individuals in order to, allow American workers to get jobs in what is becoming a more difficult workforce. So that's my thought, but we'll see the actual implementation. So I would say if you have a concurrent H-1B, I think you're probably fine to file. People outside of the United States are the people that I'm most worried about right now, because there's just not clear guidance. Is it for people that are in the lottery outside the United States, or is it for people filing for new employment outside of the United States? We don't know. The other big part to bring up about this, in case there's not a question about it, even though I feel that filings in the United States are fine and likely not subject to this fee, what we don't know is international travel going to be utilized as a triggering mechanism to require the fee? So what I mean by that is, if you're in the United States and you file a transfer or a change of status, and they do not ask for the fee when the case is approved, if you exit the United States and need to apply for a new visa, or even need to come back and enter the United States through CBP, are they going to at that point say that the fee is required? My assumption is that if they were to try to do that, they would enforce it when an individual needs a new visa, because I think it's going to be hard for them to try to have CBP govern this and be like, I need to see your receipt. And so I think it's going to make their job much harder. Whereas abroad, I think it's much easier for the consular officer to request that information, or the consulate to request it before the interview is even scheduled. So we're in a holding pattern, a wait and see on how that's going to work. But I think that the filings in the US should be safe. And until I hear otherwise, that's how our firm is going to try and proceed. But this is a rapidly changing thing. On Friday, they basically made it seem like anyone outside the US couldn't get back in unless they paid the fee. They cleared up on Saturday that anybody that's on an H right now is okay. And that's about all they found. There's a little bit of an argument to be made that they did clarify that extensions in the United States are safe. And so that's great. But the remaining question is, how does it impact transfers? Concurrent employment being another example. But my holding for the moment would be, I think if you're in the US, you're okay to file without paying the fee.
Thank you. Thank you so much, Justin, for taking that up. And Ricky, I see you have a lot of questions. Why don't you just join us on call? It'll be better. And the number is 425-436-6335. And the access code for the call is 988-888. Don't forget to subscribe to our channel, friends, watching us wherever you have joined us. We are live right now on YouTube, LinkedIn, Facebook, and also check us out on X and on Instagram. So thank you, Justin, for that. And Well, my next question would be, are companies likely to sponsor fewer H-1B visas due to the new rules? I mean, we have seen, I think this year also it was comparatively lesser. So, what do you think is going to happen next?
So, I mean, it's entirely possible that this holds a chilling effect for the H-1Bs. You know, and in terms of the lottery change, I think you'll see employers be less willing to put people in at the higher wage levels to give them an advantage. I think you'll still see people sponsoring, but they're going to have to sponsor at a level one or maybe a level two and hope for the best. So I think you could see it lowering the amount of people that are willing to put their names in the hat. That being said, I think that the people that are going to be most drastically impacted in this circumstance, regardless of how the interpretations of everything end up being, is going to be people outside the United States during the lottery process. I think that if you are a company and you're sitting there saying, we're going to file for this person outside the US and we're going to have to pay them a high wage to ensure, you know, that we're going to be successful in their case being selected. And then we're also going to then have to pay $100,000 fee in order to get that person into the US. If you think about that, if you're even paying someone, let's say 125 or 130K, it's like a $230,000 investment, taking away even the fees that are going to be associated with the filing itself and the registration, which has gone up. So, I mean, I think if you're outside the US, the path to an H-1B is so tenuous that you're probably going to see people start to just try different opportunities. Maybe you see a spike in the L's as a result. I'm not sure, but I think that companies they're going to try to retain talent, but they may become less willing, if not downright unwilling, to take chances on people that are working at their foreign affiliates outside the United States or people that they plan to sponsor in the past year or two that aren't in the US. So I think that's really the biggest chilling effect that it's going to end up having is just you're not going to see people coming into the US on new H-1Bs. Or if you do, it will be a very slim number of people. That, though, does not take into effect Section C of the proclamation, which carves out exemptions, which are quote unquote in the national interest. We don't have an understanding of what that exemption looks like or how an individual would qualify. I think the most clear cut example of it would be healthcare workers, you know, doctors, people that are coming in to work in areas of the United States that have legitimate, provable shortages for the type of work being performed. Those people could be the ones that end up with exemptions. Taking a step back and kind of looking at who is in the White House and what kind of behavior we've seen from that person in administration over the past 9 months. Could there also be a path where the exemption basically applies to the companies that are run by all those guys that were standing up there with him during inauguration? Maybe. You know, I don't know. Until we have that guidance, I don't know how they're going to claim it. But would I put it past the administration to say, gosh, we got to give Microsoft an exemption because they're just such an important company, you know? Or, oh, we need to make sure Meta has an exemption. Do you guys really think anybody on an H with Tesla is going to have to pay the fee?
Well, it's so hard to say anything right now, right, Justin? Like we are all confused who's going to be even paying the fees, I mean the employers, the workers, because it's such a huge amount, or is it going to be like a joint payment that they'll have to do now? And we have questions about the selection process also. I can see Seema Patel asking, because we had started the beneficiary centric selection process. So what are the implications of that?
So how does the proposed new rules on weighted selections for higher wage levels impact eligibility for an H-1B visa? So eligibility itself is still supposed to be contained within the idea of, is the position a specialty occupation and is the individual qualified for the position? The types of questions that USCIS is supposed to ask when they're adjudicating. So eligibility remains the same. The process through which an individual justifies an H-1B, it's there, it's concrete, it is unchanged. What is changed is your probability for being selected. So, and this kind of gets into one of the arguments for whether or not this is legal. Regulations, which I wrote down before the call, so that's what I'm looking at. You would be looking at INA 214G3, 8 USC 1184G3, state that the system is supposed to be random. So introducing a weighted scale to the system would seemingly remove the randomness of it, right? Because obviously, if there's a higher probability of you being selected because your employer files at a level 4, you have an advantage, and the randomness of the process no longer exists. It's
Exactly.
like
You wouldn't call it a lottery even.
yeah, exactly. And so, it's like, take for example the master's lot, the extra 20,000 allocated for people with master's degrees. That's still done randomly, right? That's still random. It's just, picking balls out of a machine or numbers out of a hat. There's a randomness to it. So that's how you can justify saying, it still complies with regulations. When you change it to a weighted system, you are kind of flying in the face of the regulation as it's been drafted, because you're basically saying, no, these people get more bites at the apple because their job is harder, or requires someone to be paid more because the skills required for the position are higher. So it's interesting whether or not it's even going to be something that is allowed to be implemented legally. But that being said, the people that are given this weight, it's interesting because you think about the mechanism through which they're going to actually be able to do this. You're now going to have all this information provided in March. So in March, you're going to have to know definitively where someone's working, what they're going to be doing, and how much they're supposed to be paid, right? So all of that needs to be determined in March, and then that information has to be submitted with the registration, right? If you're a company that's, say, a consulting company, and you sponsor people in the lottery under the understanding that when you find out they're selected, you're going to be verifying, if their project is available, what project you're going to place them at, all of that stuff, your life gets much harder because you're now tying yourself to a specific area of intended employment and a specific wage level. So I think that makes it harder for consulting companies. And the thing about it is I've already heard the chatter coming out about, well, how do they, what about people gaming the system? What if you say you're going to file at a level 4 and then your case gets selected and you end up submitting the petition with a level 2? They've already spelled out in the regulation, minor changes may be permissible, significant changes will not. So what I mean by that is you can't say I'm going to put somebody in Silicon Valley, pay them a level 4 wage, and then the case gets selected and then say, actually, I'm going to do a level 1 in Wyoming, right? USCIS is going to, on its face, say, when you submitted that registration, you were committing fraud because you had no intent to actually have the person working there. So that's the first way that they're not allowing someone to game the system. The second way that they're not allowing someone to game the system is multiple entries. And what I mean by that is I own company A and my buddy John owns company B. I put in for level 4 and my buddy puts in for level 1 with an understanding that when the case is selected, we can choose which one the person's going to go to, right? Because it's beneficiary centric. Well, they've already come out and said, if you do that, they will only consider the lower wage. So if 2 people sponsor you and one's doing a level 3 wage and one's doing a level 2, you are entered 2 times at a level 2. So that is another safeguard that they've already said will be implemented in order to protect the integrity of this process. The third one that I've seen, and the last one that I'll discuss, I say I'm going to file a level 4. I get selected. I file a level 4. I get approved. October 2nd or 3rd, I file an amendment to drop them down to level 1 or 2. That's already been baked in to the proposed regulation. USCIS has stated, if you file an amendment after your case is approved and the amendment, drastically lowers someone's wages or changes their project or whatever, they're going to look at that application as if you committed a misrepresentation when you filed that initial H-1B, because they're going to, say, based on the facts, it looks like you're attempting to game the wage level system to ensure that the individual is selected, and then you're subsequently dropping the person's wage down. So those are some of their quote unquote safeguards to allow the system not to be negatively influenced or impacted outside of the way in which they want it to.
Well, thank you so much, Justin, for that as well. And, we have questions. Another one is, I think, what is a good way to contact USCIS to seek clarity on this topic?
You don't.
Is there any way out?
You don't. They don't want to talk to you. There used to be an entire office that existed to deal with
Yes.
inquiries, the USCIS Ombudsman Office. Trump got rid of it right after he got back. It was one of the first things they did. So you don't. They're not going to say anything to you. They're not going to provide you with any information. The chaos for them is beneficial. And I don't know if it's an intentional act, but if you look at it from this perspective, until we know exactly who the impacted parties are, we can't litigate, right? I can't take plaintiffs before a court and say, it's these people are trying to file transfers and they're going to have to pay $100K fee. And I'm going to dispute the legality of that. USCIS could very easily come back and say, what the heck are you talking about? Like, transfers aren't applicable. This is a moot claim. There's no reason for you to be before the judge. So that's the thing too. I don't know if that's something that they're doing on purpose or just because they're so inept. But I don't know. But I think that in terms of contacting USCIS to seek clarity, I guarantee you AILA has attempted to root out information from them. And the fact that AILA has still not come out with a hard stance, and we are now on Wednesday, is telling. Because that means that they are basically not talking to us.
Yes, that's true. Thank you so much, Justin. But folks out there, I would say subscribe to our channel, because whatever latest information we receive, we're going to bring it to you firsthand. And our handle is at Immigration Talk Show. Check us out on YouTube, LinkedIn, Facebook, X, and on Instagram. And also check out Attorney Justin Rivera from Wasden Immigration Litigation. Check out their LinkedIn page as well, Wasden Immigration Litigation. So yes, Justin, thank you for that. And we do have ZQ also asking a question saying, Justin, will your firm debate this fee hike in court or initiate a litigation case against this proclamation?
So let's take those each one at a time. I think that obviously we're looking at this to litigate. We're looking at both circumstances, to be blunt. So are plenty of other law firms. In regards to the proclamation, until we are clearly defined on the impacted parties, we're not able to proceed. Once we have that understanding, and really the understanding is basically going to come down from people are filing cases, and if no one gets an RFE saying that they have to submit a fee, we'll know that it's not impacting anyone in the United States. Once we see that, if in the alternative, they do begin to demand the fee from people in the US, now we have a clear definition of who the plaintiffs are. We're able to litigate using the companies as, the plaintiffs. So that fee hike, the 100,000 fee, that's one thing. The other thing is the wage level fee, the weighted lottery, right? The weighted lottery at present is a proposal. We cannot litigate a proposal. We'd have to litigate the final rule. So until a final rule is published, there's no action for litigation. So in both circumstances, I see a sense where we're in a bit of a holding pattern until we have more information. If I'm USCIS, if I'm DHS and I'm smart, this proposed rule for the fee increase when it's, for the wage levels when it's finalized, I punt it to next year. And the reason why is it gives you an opportunity to hone out how the process actually works in their system, but it also creates an opportunity to push litigation away. Because if they try to quickly implement the policy for this upcoming lottery, it won't be until like December at the very earliest. And a realistic time is going to be February. Right when it comes out, they're going to be hit with litigation for preliminary injunctions to stop it. And I would definitely see judges at least saying, pause. What is going on? You guys are going to implement this policy next month, and it just came out. So I think that there could, be an avenue there where you'll see them kick it further. So yeah, I would say for our firm, we're looking at both issues. We're considering litigation in both instances. Once we have concrete information, it will be a cause that we will be taking up. It's just the avenue, by which we will get to the plaintiffs that we need in order to litigate.
Yes, Justin, thank you so much. And we have Karthik. I think the first part of the question we already discussed in our session today. So I'm going to take up the second part, which is where he's saying effectively been dismantled in favor of a pay-to-play model. Is this the end of merit-based immigration or the beginning of economic gatekeeping? Any comment on that, Justin?
So yeah, it's interesting. Sorry, I gotta bend my leg to become more professorial. When you look at the proclamation, right? What is their baseline? What is it that they're saying is the reason why this needs to be implemented? They got a little bit about saying, well, we don't want people, misusing the H-1B system. We don't want people to misuse it because they're gonna lower the wages and make it more difficult for people, But buried in there, outside of the studies, which, by the way, can we take a step back and talk about this just real quick? How in the world in the proclamation are they going to cite studies without identifying who the parties were in the studies or what the studies were? I was baffled to look at that and to see them say things like one company laid off, X amount of people and in the same year filed Y amount of H-1Bs. Okay, who's the company? What was this? How did you perform this study to procure this data? Like, where does it come from? It would literally be like if we were in high school and you had to submit a term paper and you didn't cite anything. You just use words like people are saying, or, I think I've heard, which admittedly, the guy that runs our country does a whole lot of that. But that was really something. But buried in there, if you pay enough attention, what they're saying is, it's too difficult right now in this economic climate for people, US born people or US citizens, to compete. And because of that, we need to set up, great term, by the way, the economic gatekeeping mechanisms, because it's not going well, which I think was interesting considering that this administration is trying to constantly tell you that the economy is doing good, but is now saying at the same time, actually, the economy is not doing that good. So we need less people coming in. So yeah, I mean, yeah, it's economic gatekeeping straight up. There's not really another way to say it, because they're saying we can't have people come in, right? Because this is all 2 months left. They're saying the people here in the United States, they're already here. We can't do anything about them, so we'll screw with them through the lottery and FDNS investigations and all that. But if you're outside the US, you can't come in because unless you pay the $100K, right? You can't come in. And our justification is you can't come in so that you can take the open job from a US citizen.
Exactly. There's so much happening, and whoever is coming in is actually required to pay a huge amount of money, whichever visa is that. So yes, thank you so much, Justin. And also we have Ricky, Seema, and Karthik. Thank you. ZQ as well. Jadav has a thank you, Jadav, for joining us. He's asking, does the $100K H-1B application fee violate the equal protection clause by disproportionately excluding applicants from lower income countries?
It's a good question. I don't know. I would have to look into it at more length. Right now, my general argument regarding the implementation of the policy is, where is the president's authority to create this? Where is the authority to create a $100,000 fee, an additional fee, without going through rulemaking, without actually utilizing Congress and creating a law that says this is what's happening and why it's happening? So I think in that regard, there's room to say, is this legal or is this not legal? There will definitely be other arguments posited, and an EPC claim could exist as well. But I definitely think you have an APA, Administrative Procedures Act claim. I mean, an on its face claim as to whether or not the president in his authority can subvert notice and rulemaking policies. Notice, by the way, that we have a great teachable moment in that. The weighted lottery selection fee is in its proposal stage, right? Because it has to go through notice and comment before it can actually go into effect and be law. None of that has occurred with the 100K fee. So what is their basis and what is their justification? Are they claiming that there is an economic emergency? And if so, what is the data that they're showing to justify that? And again, obviously, what is the president's authority? So I think you have claims there. That being said, their best argument is going to be trying to utilize the Secretary of State's authority to set boundaries on admission to the United States. I think that if that's their fight, they have a much better go of it than if they're trying to say, this applies to anybody filing a petition. So it's a wait and see. It will be litigated. It will absolutely 100% be litigated. IT Serve and other big organizations were all in meetings on Friday night after the proclamation came out. And so all of these institutions are sitting there and looking at, the ramifications of this on their business model. And I think that's going to create a circumstance where you have to litigate it. It's more beneficial to put money into litigating this with the understanding that you're actually going to see an ROI, a return on your investment that is substantial, because the 100K fee, let's just be blunt, you're not paying that fee if you're an employer that has 30 or 40 employees. If you're only generating revenue at like 1 mil to 1.5 mil, that 100K fee is really eating into your bottom line. It's a difficult thing to just take. So companies aren't
That's
going
for
to.
a lottery where there is no 100% short.
Right. And so I just don't think companies are going to take that line down. And then you bring in the other issue of the weighted lottery. I mean, the weighted lottery is also problematic in that companies are going to now be told, like, you have to pay or be willing to pay a level 3 or 4 wage to someone that's, probably right out of college or maybe has 1 to 2 years of experience. Because if you don't agree to pay that wage, you're diminishing their opportunities to be selected. So you're going to see litigation on both issues. I think it is an inevitability that both issues will go before federal judges. It's just going to be a matter of when are the data points in place that allow litigation to proceed with, an understanding of it. The proclamation is going to be litigated sooner once there is absolute certainty as to who's the impacted parties. The proposal, the proposal here for the weighted lottery, litigation for that is going to it's going to definitely come once there's a finalized rule. Because we have to be able to analyze that finalized rule before we can understand what it is that we're going to attack. But there's already arguments coming. I promise you, we're all already strategizing about how we're going to argue against the legality of this.
I think we all need answers, more clarity, and we'll just have to wait and watch. It's all too soon, I think. We'll just have to wait for things to settle down and, yeah, more answers. So, Justin, I'll just take a couple more minutes from you, and we do have more questions. So, just say, for example, I am an H-1B holder planning to travel abroad. Will I be able to re-enter the US under the new rules?
Allegedly, if you are subject to an approved petition and that petition was approved prior to the implementation of the proclamation, which was Sunday morning, you are fine. So if you are within that category, you are okay to travel. I have not heard, and we're on Wednesday, I have not heard anyone come out and say, my client was refused entry into the United States under the guise that they have not paid the fee. So you should be fine. That being said, another attorney actually informed me on Monday that an employee of one of the companies that her firm represents actually proactively asked a CBP officer about the fee and said, hey, I know I'm okay to come in. I just want to make sure that I don't have to pay the fee. This CBP officer, who, let's understand, is an officer. They're not a supervisor. They're not somebody actually operating within the, federal government, the White House. This officer said, oh, you're fine to come in this time, but you're going to pay the fee when you file an extension. That doesn't even make sense because it contradicts the guidance that they've put out, where they've said renewals are supposed to be safe. Yeah. So this goes back to what I'm talking about. I don't know if anyone has a clear-cut understanding or explanation of who the impacted parties are. I can just make my best guess in terms of, speculation. But I can say for you, if your approval came in, if you were approved before the proclamation goes into effect, you're fine. If you filed before the proclamation goes into effect, you're supposed to be fine. So in any of those circumstances, you're okay to travel. Understand that traveling is now more dangerous than it was before this administration took over. There is an increase in CBP secondary inspections. There's been an increase in expedited removals. So all of those things need to be considered when you are traveling. So my advice to you would be, in your circumstance, you can travel. Step back and analyze whether or not the travel is mandatory or whether or not it's something that can be put off. Mm-hmm. And if your risk threshold is, I got to travel, by all accounts, you're fine.
Okay. Well, thank you, Justin, for taking that up. And the next question I wanted to ask is about exemptions. So are there any exemptions to the $100K fee for H-1B holders re-entering the U.S.?
There's an entire subsection that exists, Section C, the national interest exception. There is an entire part of this that says there are people, businesses, and even entire industries that could be exempt at their discretion. So that is a carve out. What does that look like? We don't know. There's no guidance. There's no factor test. There's no clear-cut explanation as to how do you fall into national interest versus how do you not fall into national interest, right? So we don't know. There's two debating schools of thought on this. There's going to be, basically a sort of carve out for people in industries that are legitimately understaffed, or maybe for individuals that are serving communities that are impoverished, and just don't have employees. Like rural town doctors would be, something. I think if anyone's going to get a national interest exemption, it'd be, a doctor who's going to practice in a small town that does not have doctors or a lot of doctors. That's one thing that I could think of. There could definitely be more. What about people who are working on projects for national defense? It's in the U.S.'s interest to have those people admitted to the United States as well. So you could see waivers for that too. So that's kind of the A of it, which I think if we lived in a rational world would make the most sense. The B of it, like I discussed earlier, is crony capitalism. Exemptions will be carved out based on what companies are willing to, what companies and schools, because I don't think we've even touched on this. As of now, this applies to entities that are cap subject and cap exempt. So that means things like universities, which, traditionally they're cap exempt. They're now going to be looking at fees. So are these corporations, these companies, going to kiss the ring in return for an exemption? I don't know, but I sure know that Tim Cook not too long ago gave a big shiny gold thing to Trump in the Oval Office. And I don't think he would do that unless he was getting something out of it.
Mhm.
So do with that what you may.
Well, thank you for that too. What a perspective, Justin. And I think we're almost coming to the end of our session today. But before we leave, if you think about the H-1B and tech and the healthcare companies, make most of it. So how do you think these companies are responding to the new H-1B regulations?
So I can't speak for healthcare because I don't represent clients in the healthcare space. And so to do so would not be fair. I can say tech is in a pretty hard pause right now, to be honest. I don't think there's a whole bunch of people riling up to file petitions without a clear understanding of whether or not they meet the threshold for the 100K. I think slowly it's going to turn into them saying, okay, we're going to file, but foreign talent we might have to hold off on or find a different method of getting that individual into the United States. So yeah, I mean they're in a pause. They're trying to figure this out the same way we are, and they're talking to lawyers just like we are. Look, Microsoft was one of the first big players to tell their employees on Saturday post proclamation, you got 24 hours to get back to the United States. And I promise you, Microsoft is employing immigration attorneys that are as smart as me or much smarter, probably much smarter. And if their interpretation of that was we got to bring everyone back, then it's in line that everyone else would have been in the same boat. Now that we've rolled back from that, the next step in this process is going to be which filings are going to require the fee. And there's a pause there because even if you're a big company, think about it. If I'm saying I'm going to file a transfer for this guy, I got to pay all these fees already to file the transfer, right? And then I got to pay my attorney to do the filing, right? And then once I file, I get an RFE telling me you need to pay $100,000 or this person isn't going to get their approval. You're going to pause. You're going to say, why would I throw money into a trash can and light it on fire? So you're going to see that happen until people are actually putting forth petitions and seeing what the end result is. And nobody wants to be the guinea pig, right? Nobody wants to be the guy who's like, I'll do it. I'll gamble my immigration future on moving, transferring to another company or changing status from my current status back to H-1B or however that situation will come up. So until those, I'll call them plaintiffs for lack of a better term, because I think inevitably there'll be plaintiffs in litigation. Until those plaintiffs come to light, I think it's going to be a chilling effect. I think you're going to see less petitions filed probably between now and early October.
Definitely. I mean, it's just a lot to take in. I think we have seen a lot of changes, especially with regard to immigration, right, Justin, ever since President Trump joined office 2025 January. And it's
Oh
just
yeah.
been a few days and so many questions. And in fact, if we just talk about H-1B, we recently saw a fee hike, and now this is huge. So, well, last but not least, if you have anything to say before we leave, to all our viewers, it'll be really nice.
So I do want to talk about something that kind of fell through the wayside when all of this was happening. And that is Project Firewall. Project Firewall was announced by the Department of Labor. Okay. It came out kind of quietly along with all of this other stuff. And what people like, everyone's freaking out about the proclamation saying, oh my gosh, who's it affect? We're freaking out about the wage levels saying, oh my gosh, who's going to, is this going to screw me over as a college student or me as someone abroad who's trying to get in the H-1B lottery? Project Firewall is basically the DOL coming out and saying, we're going to make a point of investigating. We're going to be kind of walking in lockstep now with FD&S and going after companies for wage-based issues. The reason why that is important is FD&S's scope is limited to basically verification of information provided within the petition. When it comes to things like wages, payment of wages, appropriate wages, whether or not the petitioner made the H-1B employee pay fees they're not supposed to pay, all of that arguably falls into the prism of DOL. And so FD&S, when they ask for that information, if you utilize competent legal representation, you can push back and say, we're not going to turn over that information because you don't have a right to it. DOL has a right to it. DOL exists for that purpose. There's not a whole lot provided about how DOL's Project Firewall is supposed to be implemented. But if I were a betting man, my implementation policy would be this. FD&S officer goes to employer A's headquarters and says, hi, I'm here to talk to employer A. And next to me is DOL officer B. And he's here to talk to employer A too. And then when employer A sits down, they're basically in a situation where if they don't provide the information that's being requested, they're going to be non-compliant. And so this basically puts more pressure on employers to make sure that they are absolutely squeaky clean in terms of their petitions. I have said this until I am blue in the face during this administration, more so red right now, if you can't tell. Problems of being a youth baseball coach is they make you go out in the sun for a long time. But I cannot stress this enough. The time of filing an amendment after the guy joins the project is over. It's done. You cannot wait until the person's working somewhere else to file, because that is exactly what they're looking for. Having someone work in an area not covered by the LCA is not permissible. It should not be done. You cannot put yourself in a situation where you get caught doing that as an employer and as an employee, because you have to understand, as an employee, doing this will impact you, because eventually they will revoke your petition. And most of their revocations right now, they're trying to tie to fraud. Because if they can tie it to fraud, they're going to give you, the employee, a permanent bar of entry to the US based on 6 CI fraud or misrepresentation. And I promise you, they have stretched the fabric of fraud as far as it can possibly be stretched. So all of that is to say, Project Firewall is something that we need to consider as an issue. It's not something that we can say is going to go away with litigation. It's not. It's completely permissible. So we need to be prepared for it. As an employee, you've got to make sure your petitions are proper. You are entitled to a copy of your LCA as a matter of law. Okay? That is something that you have a right to. You should know what is on that LCA because it dictates your immigration future. The other part, the last part I will leave on, because I know I'm, at a pulpit right now. Employers, you guys got to stop leaving petitions open after the employee leaves. You have to stop doing it. I understand that there is a long-standing practice in the industry, particularly for consulting organizations, that when an individual transfers to another organization, you don't withdraw the H-1B because you want to give the employee the opportunity to return in the event the transfer is denied, or in the event that the individual is later let go by that transferring employer. You guys need to understand, in the strictest interpretation of DOL, unless you can present documentation affirming the fact that that individual was terminated with your organization, if you leave that H-1B open and you are eventually investigated by the DOL, Department of Labor, or FD&S, there's a very real possibility that you will receive a judgment to back pay wages for the entire time period that that individual was not paid. And I am telling you guys that because I have seen it firsthand. I have been involved in DOL investigations as recently as last month, where people filed H-1Bs for their friends, for their buddies, for their relatives, and those people came into the United States. They didn't have work. You didn't run payroll, but they never pulled the H because they said, well, that's a family friend. and we didn't want to screw him over and we didn't want to make him have to leave. Well, you know what? That family friend eventually found an employer in one of our cases 2 years after they came into the United States. And when they filed a transfer, that person decided if the only way for me to get my transfer approved is to justify why I didn't maintain status because I have no pay stubs. They reported them to DOL. So that person threw the company under the bus because they knew it was the only way for them to get their transfer H-1B approved. Well, guess what? Their transfer H-1B was approved. And on top of that, that company is now dealing with an $83,000 judgment, all because they decided it was nice to leave the H-1B open. So don't do that. Just don't. Employers need to think about the best actions for the company, and employees need to realize they have a right and should be making sure that they are in compliance with their H-1B. And that should not create a relationship in which the parties are adversarial, right? Everyone should be on the same page because ultimately what everyone should strive for is the best possible outcome for the employer and the employee. So I know I gave you guys a lot to consider and a lot to digest, so I will leave it with this. Our law firm obviously is open to take in consultations. If anyone needs a consultation on anything, prospective filings, international travel, litigation, obviously our door is open metaphorically. You can reach out to us through our website and our team will work with you to schedule something.
Thank you so much, Justin. I mean, that was a lot of good information. So thank you for sharing all of that, and also for for so patiently taking up each of our questions, not just mine but also from our audience today. Lovely audience, great questions, so thank you so much each one of you. And don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Also check out Attorney Justin Rivera on the link which you can see on the screen, and check them out on LinkedIn as well. And they are Wasden Immigration Litigation. So thank you, Justin, really today. It was lovely having you. And I'm so glad that the internet also was supportive of our session today. So, yes, thank you once again.
You're very welcome. Looking forward to more discussion in the future. Have a good rest of your day.
Me too. You too. And have a wonderful day ahead. So, thank you once again. Friends, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Check us out not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. And also feel free to stay in touch with us. And that you can do by commenting wherever you're watching us. Feel free. I know you have a lot of questions, so keep them coming, and we will try to come with good answers for you. And don't forget to hit that bell icon, because whenever we have the latest updates, we are going to bring them to you, for you. And yes, the $100K for H-1B. It's a big news, and there's so much more unfolding. You can say every hour. So stay in touch with us. And thank you everyone for joining us. Bye for now.